You already know the classic story about the abused spouse who fears calling police because their partner controls their immigration status. What most people do not know is that this exact nightmare applies to same-sex couples too, and the law finally caught up in some pretty important ways. Let us start with the big one, the Violence Against Women Act, which, despite its name, has nothing to do with your gender at all. It protects any spouse of a United States citizen or green card holder who has suffered abuse, and that includes husbands, wives, and same-sex partners equally. Here is the twist that trips people up constantly. You do not need to be married to qualify for every remedy. If you are in an intimate partner relationship that counts as a marriage under the laws of the state or country where it happened, you may still have a path forward. Think of the VAWA self-petition like a secret side door in a locked house. Instead of needing your abusive spouse to file paperwork for you, you can file it yourself, quietly, without them ever finding out until it is already approved. Now let us talk about the U visa, which sounds like a random letter grade but is actually a golden ticket for crime victims. If you cooperated with law enforcement after suffering a qualifying crime like domestic violence, you could be looking at a path to lawful status and eventually a green card. Same-sex couples sometimes worry that local police will not take their case seriously, and sadly that fear is not always irrational. But federal immigration law does not care about the gender of your abuser. It only cares whether the abuse happened and whether you can prove it. Proof is where most cases live or die, so let us demystify that part. Think medical records, police reports, therapist notes, text messages, even a sworn statement from a friend who saw the bruises. All of it builds the puzzle. Here's a common misunderstanding that causes real harm. People think they have to leave the country to apply. In most VAWA and U visa cases, you can actually stay right here in the United States while everything gets processed. Let us zoom out for a second and ask why this protection even exists. Lawmakers realize that if your immigration status depends entirely on your abuser, they hold a leash on you, and removing that leash is basically the whole point of the law. History time, but we will keep it snappy like a movie trailer. VAWA passed in 1994, and it took years of advocacy afterward to make sure LGBTQ survivors were explicitly included and not left standing outside the door. Some people assume immigration lawyers only handle green cards and visas for tech workers or families. In reality, a huge part of this work is trauma-informed, meaning your lawyer should treat your story with care, not just paperwork efficiency. Preparation matters more than panic here, so if you are in this situation right now, start documenting everything today, even in a private notes app. Small, consistent evidence collected early is worth more than a dramatic story told later without proof. Confusion is normal too, especially around timelines, because these cases can take months or sometimes over a year depending on the agency backlog. That wait is frustrating, but it does not mean your case is weak. It usually just means the system is slow, not broken. The honest truth is that no one should have to choose between safety and their immigration status, gay, straight, married, or not. The law finally recognizes that, even if it took some very loud voices to get there. If any of this sounds like your situation or someone you know, you do not have to figure it out alone. Do you want to learn more about how we help? Check out our links in the description.